So the training tonight is a new one we haven't done before, but it combines a bunch of different areas in general about tenants' privacy. Uh, so we're going to go over different areas of landlord-tenant law that affect tenants' privacy, right? So what is the basic principle underneath, like what is private when you rent an apartment? What the law concerning things like security cameras and microphones and other things that a landlord might put in the common areas of the building, the laws about when the landlord can get access, can come into your apartment, and what they can do when they're there, and your rights to regarding law enforcement coming into your apartment. And then it didn't make it on the agenda, but we're also going to talk a little bit at the end about the privacy of people when you're the applicant, when you're applying for an apartment, and what a landlord uh, can look into or can ask of you. All right. So just to start, everything that we're talking about tonight is going to revolve around a basic concept. It's a legal concept, but also kind of a common sense concept, which is called the reasonable expectation of privacy. And this is a concept both in landlord tenant law, but also in constitutional law, as we'll see when we talk about law enforcement. And what it basically means is uh, you're entitled to privacy where a reasonable person using common sense would reasonably expect that they can't be seen or heard from outside the apartment. It's a very simple concept, but it's an important one. So, a lot of this may feel obvious, but it's actually not always true that law follows common sense or is obvious. So this is kind of an unusual situation in that sense. So this would mean, for example, obviously, we don't have privacy if we are standing in front of the window and the shade is up. We don't have privacy, if we open the front door of our apartment. We don't have privacy in the parts of the apartment that can be seen, right? If the door is closed and the shades are down, then we should be able to rely on our common sense expectation of privacy, right? Like that sense that, I would have no reason to think anybody can see or hear me. We should be able to rely on that. The law should allow us to be secure in that expectation, right? So that it's easier to say what's not included in that than what is. So, as I was just saying, obviously, like, you know, we all know if we're standing in front of the window and the curtains or the shades are open, we're not private, right? Anything that can be seen through a window is not private unless we lower the shade. If you open the door to your apartment, then anybody in the hallway can see whatever is within that line of sight. Again, not a surprise there. Um, any sounds we make in our apartment that could be heard outside of it, right? Again, not surprising then that people might hear it, might listen to it. Smells that escape the apartment, and of course, anything outside the apartment itself in the common areas of the building is not private, right? So hopefully, everything up to this point, is pretty self-explanatory, and you're wondering why you need a lawyer to tell you this. Again, it's such an exception when the law actually follows common sense that uh, it needs to be pointed out. Um, so basically, anything that a landlord does that violates that basic expectation of privacy, right, that would actually be able to see you or hear you at those times when common sense would tell you that you're private, is a violation of your right to privacy as a tenant, right? So this most often comes up with security and monitoring devices that landlords put in the building, like security cameras, which may be enabled for sound, right? Those are legal in the common areas of the building, because again, we have no expectation that what we're doing is private in the lobby or the stairwell or the hallways, right? And where the law is actually pretty bad on this means that even if a landlord takes a security camera and points it right at your apartment door, right? It's in the hallway on the wall opposite your door, and it's pointing right at your door, which is obnoxious and invasive, but legal. Because again, the camera will only see what a person would see if they were standing there, which is to say nothing at all when your door is closed. And when your door is open, only the parts of your apartment that are uh, visible from the door. That does not mean it's okay. It's, when landlords do that, it's almost always, or I should say always, an act of bad faith trying to gin up some evidence, that a person doesn't live there, or trying to, fish for something that they might be doing wrong. It's also really creepy. But under the law, under this basic expectation of privacy, it is legal. So if we wanted to change that, we would have to lobby elected officials to specifically pass a law outlawing that. But again, because that camera can only see the outside of your door if your door is closed, anyone going in or out of the apartment, to the extent that they're in the hallway, or if you open the door, what a person standing there would be able to see, right? All of that is not part of the expectation of privacy. Meaning, in other words, we all know that if we open our apartment doors, people can see in. We all know that when we step outside the door and we're in the hallway, we're not private. Um, However, security devices are illegal if they can pick up any kind of image or sound that an ordinary person with unaided eye or unaided ear could not detect, right? So, for example, and I hope these are not common occurrences, but I have seen examples of landlords using all of these infrared cameras, right, that can detect heat signatures and see things that are going on inside an apartment through the door, through the wall. Illegal, right? Because it is seeing you when you have a reasonable expectation of privacy, right? Our expectation that that people can't see us, it should not include Superman who has X-ray vision. So anything uh, that reproduces that effect, like sees you through the wall, would be illegal. Right? Microphones that are more sensitive than just the human ear, right? And that's more common than infrared cameras, right? But something in the hallway that is sensitive enough to pick up, you talking in your apartment quietly enough that a regular person couldn't hear you. That is an illegal invasion of your privacy. Illegal in the sense that it would violate your lease and your rights as a tenant. Um, Hopefully, very unusual, but vibration detectors or things that can determine, if you're in the apartment and moving around, or how many people are in the apartment, and any other kinds of devices that they've come up with that I haven't seen, that can see or hear you in a situation where you would not expect a person to be able to see or hear you. That would all be illegal. Oops. So this should go without saying, but in my experience, nothing goes without saying when it comes to landlord tenant. But no wiretaps, no bugs, no spy microphones or cameras, no peepholes, no secret forms of monitoring. I wish we could just say that, of course, that doesn't happen, but those things do happen. Okay. So moving on, landlords often request or demand or take for themselves access, meaning coming into the apartment. And it's really common to hear. I've seen this. I've seen uh, lawyers say this. I've heard judges say this. I've heard the police say this. I've heard serious pundits on TV say this. Uh, and every single one of them is dead wrong when they say it's the landlord's property, he can go where he wants. That is just not true. And that's not just my opinion or the opinion of the housing movement. That is legally false. And if you answered it on a law school exam, you would fail. The reason for this is that the right to come and go as you wish, the right to go in and out of an apartment, and the right to decide who else can go in and out, right? Those are property rights. An owner of property has those rights, except that if you're a tenant, the landlord sold those rights to you for a temporary period of time, right? It can end. But in the meantime, they don't have those rights anymore. They're yours. You bought them and paid for them. And the landlord willingly and on purpose gave them up. So, no, it isn't true that it's the landlord's property. He can go where he wants. It's no longer just his property. Legally, you also have some property rights, and the landlord no longer has those rights as to your apartment. So you absolutely have the legal right to decide who comes in and who goes out. And that's the most important thing to remember. And it is, again, even judges will simply say the opposite. You are not a guest sleeping on the landlord's sofa. You're a tenant who has bought property rights. That's what a tenancy is. But you should always assume there's a but with a lawyer. There are some parts of those rights that the landlord holds on to. And the landlord holds on to them, one, because New York state law says that landlords have to retain these rights, and most leases also say it. So the landlord retains, even when they're renting to a tenant, a limited right to enter the apartment. And it is strictly described by law. It is access for necessary repairs and inspections, right? So the Housing Maintenance Code says they get that. That's a city law. The Multiple Dwelling Law, which is a state law, says they get that. And almost certainly, if you have a written lease, it says that they get that. But that's not an unlimited right. First of all, it is only to the extent that they have to do repairs and inspections, only to the extent that those things are necessary, right? They can't decide that they want to replace all of the light bulbs in your apartment with new light bulbs just in case, and then use that as an excuse to come into your apartment every day. The repairs have to be necessary, which isn't defined anywhere in the law, but we usually take the position that it means it would be a violation if they don't repair it, or it would be a breach of your rights under the lease if they don't repair it, or you've specifically asked them to repair it. And inspections should be connected to repairs, not just, hey, I wanted to inspect your apartment. Right? Inspections should be for the purpose of checking conditions, determining repairs that need to be done, or inspections that are required, say, by the landlord's mortgage agreement or their insurance. Right? Even then, access, the law says, can only be with reasonable notice. HPD has actually passed regulations that say they understand that to mean 1 week notice, right? Not, I want to come in right now, right? 1 week notice. And it's not written down anywhere, but it should be implicit also with some good faith flexibility so that if they say, I want to access your apartment at 1 in the afternoon on a work day, you can reasonably negotiate with them about when that works for you. They can't just say, you know, cancel your brain surgery, be home on this date, or I'm evicting you. The only exception to that is in emergencies. If there is an immediately threatening or harmful condition, a landlord can enter an apartment without advance notice and even without permission, right? But this is very limited, right? An emergency doesn't mean I just remembered that I need to repaint your apartment. It doesn't mean I suddenly became suspicious about something you're doing. It means if I don't fix this right now, very bad things will happen to the building, to the downstairs neighbor, to the whole block when there's a fire. So examples of this are like water's pouring through the floor into the apartment below, right? People can smell gas coming from the apartment. There's been some structural failure, right? And there's a danger of collapse, right? Or there's been a problem with the plumbing or the electric lines that are affecting other tenants, and they can only get to it through your apartment. This is not a complete list, but that's the kind of emergency that we're talking about. And yes, in extreme cases, a landlord could even come in without you even knowing. If you're at work or you're away, and somebody smells smoke or gas coming from your apartment, they can enter. Um, Landlords do try to stretch this as far as they can, um, but it really is a very, very strict and narrow exception. Again, only when the landlord should be able to describe, right? The following harm or damage will occur if I wait to get your permission. If they can't say that, it was illegal for them to go in without notice or your permission, right? And for all of this access, no matter whether they're doing it on 1 week notice or, they just drilled the lock because they think something's on fire, they still can only go into the parts of the apartment that they absolutely have to, right? So if they're coming in saying, water is pouring through from your kitchen into the kitchen below, there is no legal reason for them to have been in your bedroom, right? And if they come in, if you grant them access saying, yes, you can come in and do a repair in my kitchen, and they say, and they start heading for your bedroom, you are absolutely within your legal rights to say, not so fast. You can't go in there. You're only allowed in the parts of the apartment that you need to do the repairs in, or you need to observe something in. Landlords often want to take photographs when they're in their apartment. There's no written law on this. It would be an area where written law might help. But nothing is written down about whether landlords can do this or not. So, we lawyers always advise people, if the landlord wants to take a picture just tight focused on the condition that needs to be fixed so that they can, reference it, or the repair that they've done so that they can document that it was done, let them do that and don't let them take photographs of anything else. And so far, for the most part, people who take those stands and draw those lines, it seems to work. We haven't gotten a ton of pushback there. But It's probably happening out there. Again, there's no reason they should be taking a photograph of anything that they don't need to take a photograph of. And again, makes perfect sense if they've got to, document what something looks like so they can show it to their contractor so their contractor can figure out what the job is. That's probably unavoidable. If they want to take a picture of the repair afterwards so that they can prove it was done and clear the violation, that's probably necessary. If they start wandering around and taking pictures of what they consider, your messiness or your bad taste, I would tell them to leave immediately. And all of this means that there are no circumstances whatsoever under which a landlord would have a legitimate need to be looking in places like your drawers or your boxes, or since there's no way that anything inside your drawers or inside your boxes or are going to be connected to a repair. Right? Those should just be right out. The landlord should not look at anything that isn't in plain sight, except to the extent that they have to dig for something like, say, behind the wall or behind the radiator, to find an underlying problem. Okay, so that's landlords. I'm going to talk now about law enforcement. Right? So if police or ICE or any other law enforcement comes to the apartment. So unlike with landlord-tenant laws, we have a whole amendment to the Constitution about this, and it's one of the top 10. It's the Fourth Amendment. That's the exact language of it, but it means no search without warrant in your home. And again, because sometimes I've heard people, even people who are supposed to know better, get this wrong. Even though you are a renter and not the deed owner of your apartment, it is your home, and the Fourth Amendment applies to it. The operating principle here is the same as with landlords, right? Your Fourth Amendment right covers everything that you have a reasonable expectation of privacy, right? Which means, for example, if a police officer wanted to stand across the street and stare up at somebody's apartment window, and they see whatever that person does in front of the window, that would not be an illegal search because, when we do something in front of an open window, we know we're not private. But other than that, all the rules are the same, right? A law enforcement can't come into your apartment. They can't make you open your door. They can't, if you do open your door, they can't come in without your permission. They can't look beyond what's immediately visible to their eyes from standing outside, right? The difference here, of course, where landlords, can get in if they need to do a repair, law enforcement can get in if they have a judicial warrant. And until last year, this slideshow wouldn't have gotten into what judicial means. But since over the last year, the Trump administration has been really aggressive around this, it's worth pointing out the difference. When the Constitution says a search warrant, it means a judicial warrant. It means that the law enforcement who want to go in somewhere had to go to a judge, show that judge some evidence that there's a good reason that there might be evidence of a crime in there. It's not a ton of evidence, but some. And the judge has to have said, okay, and signed off on it. That's a judicial warrant. ICE, especially, has always used what they call administrative warrant, which is, a fancy name for I wrote myself a permission slip, right? An ICE administrative warrant literally means that ICE decided they wanted to go in somewhere. So they wrote themselves a very formal looking document that says, I hereby give myself permission to go in there. It has no legal meaning whatsoever. It is obviously an attempt to avoid the Fourth Amendment. The important thing about the Fourth Amendment is not just that there's a piece of paper called a warrant, it's that there was a check, however slight, however easy to get over, in which law enforcement had to go to the other branch, one of the other branches of the government, the judiciary had to go to a judge and pass at least a minimal test, right? Again, an ICE administrative warrant is just like, if a kid writes a note to their teacher that says, please excuse Johnny from school today, he is not feeling well, signed my mom. Like that is almost literally what an ICE administrative warrant is. If are ever unfortunate enough to have to be looking at one of these things, the most important thing to look for is there a signature of a judge on it, right? Um, it as of now, ICE doesn't go so far as to actually like falsely write judicial warrant across the top of their warrants. But they're obviously engaged in a project to keep pushing the limits and see what they can get away with. So who knows what they may try next. But again, if you see an administrative warrant, you don't have to do anything, right? An administrative warrant has about as much legal force as like a party invitation. You don't have to go. The judicial warrant also has to clearly and specifically describe what can be searched, which might not be the whole premises. For apartments, it usually is, just because apartments are not that big. And for homes, it usually just says the home. For other kinds of places, like an office building that has lots of different users, it will specifically say we can only search this area, and that becomes important for tenants because there's almost never going to be a judicial warrant that gives law enforcement authority to search an entire apartment building, right? There is almost no imaginable circumstance in which they would be able to make a case to a judge that says, we think there's evidence of a crime being committed, but it may be located in any of these 30 tenants' apartments, so we have to search them all. That wouldn't even clear the very low bar it takes for a judge to sign off on a warrant. So, again, if law enforcement comes to an apartment and wants to search, that warrant is almost always, I want to say always, but the lawyer in me won't let me say always, almost always just going to say the exact apartment that they're searching. So, if any law enforcement came up, knocked on your door and was like, we've got a warrant for the whole building, or they approach you in the hallway and say, we've got a warrant to search you because you're walking through the lobby, something is wrong, right? That it is almost impossible to imagine a situation in which that could be legit. Um, a judicial warrant is also required for them to put any kind of monitoring devices around. Now, unlike a landlord, law enforcement can, under some circumstances, put invasive monitoring devices. Like they can famously do wiretaps or bugs or spy cameras. But again, those can only be put in place with a judicial warrant. And actually, the the bar to clear to get a judge to sign off on something like that is much higher than to get a judge to sign off on just going in and searching. It is very hard to get. Judges reject those regularly. And there's a long history, unfortunately, in America of law enforcement bodies, because they know that a judge won't sign off on it, just going ahead and doing it anyway. So again, like, unless you're doing espionage from your apartment, in which case you're definitely in the wrong training this evening. Unless you're doing espionage or running organized crime out of your apartment, I can't imagine a judge signing off on a warrant to put a bug or any other secret monitoring device in your apartment. Oops, sorry about that. Nope. All right. I never said I was very good at PowerPoint. Hang on one sec here. There we go. And I don't know why it says exceptions to warrant requirement twice. But if you can ignore that, there are some limited exceptions, right, where law enforcement can enter someplace private without a warrant. These are very limited, right? Where they have a good reason to believe that a crime is happening right now. Right. So if they're hearing screams, help me, he's got a knife, right? They don't have to go to a judge before they come in, right? If they're in hot pursuit of somebody who they already have, good probable cause to believe did a crime, and they're chasing them and the person runs into a home or an apartment, they can follow. Although even then, they will have to make the case later that they couldn't just sort of stand outside the door and wait while their partner goes and gets a warrant. And this is the one that the Supreme Court is continually pushing bigger holes in, especially the current Supreme Court, which really has been expanding these exceptions and eroding Fourth Amendment protections wherever they can, where they believe that there's evidence or contraband that is going to be destroyed any minute in the time. They need to come in because Ray Liotta in Goodfellas is about to throw all the cocaine down the toilet. That's probably the most subjective of all of these, and it is probably the most often abused. I want to note, right, these, what's called exigent circumstances, will almost never apply to ICE. And the reason being that it's not ICE's job to enforce criminal laws, right? They're not going around trying to catch people dealing drugs or holding stolen goods. They have no legitimate reason to say, I need to come into your apartment because I think you have drugs or stolen material in there. So these exceptions will rarely, if ever, legitimately apply to ICE, right? The word legitimate is a loaded word these days, but the law is still the law and the Constitution is still the Constitution, and it's still ours, even if some other people have their hands on it. Very importantly, the landlord cannot consent on your behalf for law enforcement to enter your apartment, right? Obviously, law enforcement can enter an apartment if you consent, if you let them in. Your landlord cannot be like, I hereby consent to the police going into apartment 4C without a warrant. And again, this goes back to what we talked about before, which is they no longer have the legal right to decide who goes in and out of your apartment. They sold it to you. They don't have that authority, which means they can't pass that authority onto the police. It's not theirs. They can't do that any more than they could, give consent for the police to enter the building down the street that they don't own. Uh, so if that were to happen, right, if a landlord lets the police in, right, using their key or drilling the lock, um, that is not only a violation of your rights under landlord-tenant law, right, which might be harassment, which might be breach of your lease, which might give you legal claims. It's also unconstitutional, and anything that the police were to find in the apartment can't be used as evidence. That's what covers any time the police or law enforcement get a hold of evidence through an unconstitutional search. They can't use that evidence in court. The reason that that's the law is that until I guess about the 1950s, the law was that if the police violate your Fourth Amendment rights and they bash down your door without cause, and then they can go ahead and use whatever they find against you, but you might have a legal claim against them. But what that basically set up was just a situation in which the police could go violating everybody's constitutional rights and just, have some money set aside to pay some damages each time they do, which is to say they can force you to sell your constitutional rights. So the Supreme Court in the 1950s or 1960s, uh, you know, created the rule that says to really take away the incentive for law enforcement to violate the Fourth Amendment, anything that they get from that search, they can't use. Right. So this actually takes away some of their interest in illegal searches. Um, how well that works or doesn't work is, uh, well, at least certainly another PowerPoint and more like, uh, you know, uh, an entire life's study. Okay, we're going to move on to the last section of privacy, and this is the privacy of applicants when you're applying for an apartment. And this would also apply, if you're renewing a lease, if you're not rent stabilized, and so, renewing a lease puts you in the same position as a first-time applicant, right? So New York City and New York State, and to a lesser extent, the United States, have anti-discrimination laws, civil rights laws, that forbid landlords from making decisions about who to rent to or what to charge them on certain bases, right? So here in New York City, right, the New York City laws are the broadest. They contain categories that the New York State law doesn't contain, and the New York State law contains categories that the federal law doesn't contain. So this is the list that we have under all of those laws together, right? None of these things can be used as a basis of deciding whether or not to rent to somebody, how much rent to charge them, how to treat them while they live there, whether to renew a tenancy or raise their rent or lower their rent. And since they can't be used as a basis for those decisions, the landlord can't even ask about them. Right? So those include age. I should have put in, unless you're under 18, they can verify that you have the legal right to sign a lease. Gender or gender identity, disability, race or color, immigration or citizenship status is a big one right now, and one that is very much not part of federal law. National origin, so apart from your status, just where your ancestry is from. Family or marital status, right? How many kids do you have? Do you have kids? Are you married to their parent? Do you have a spouse? Do you have they cannot ask any of that. Whether you or anyone else is going to live in the apartment is pregnant, religion or creed, height or weight, whether you're a veteran or you're an active military service. And this is unique to New York City very much. Your source of income, including whether you're going to be using rent vouchers or public assistance to pay the rent, whether you've been a victim of domestic violence or stalking or a sex offense. And this is a big one that I'm going to be talking a bit more about, and this is very new in New York City, criminal record. And I'll come back to the criminal record in a moment because it is both new and somewhat complicated. But another area where a landlord might be getting into things that invade your privacy are background checks. So first to know that, the basic thing to know is that United States law, everywhere, this applies everywhere in the United States, it is illegal to conduct a credit check, a criminal background check, or an employment history check on somebody without their consent. I'm sure, most people, maybe everyone on the call has had the experience of applying for an apartment and the landlord asks you to sign a consent, right? And they can say, well, I'm not going to rent to you if you don't consent, except for criminal background checks, which I'll talk about in a minute. This is under the Fair Credit Reporting Act, which actually covers more than credit checks. And that's, I don't want to go too far off on a tangent, but the FCRA does provide that if somebody illegally does one of these background checks on you, you actually can sue for money. That again, that's another direction to go in. But I do want to caution, which is that it's actually possible to learn a great deal about somebody without doing any kind of background check, just using publicly available information, right? And things that are often part of public records are addresses where you lived or gotten mail or used, to register to vote or had a driver's license. Your involvement in civil court cases, your voter registration, professional licenses or businesses that you've been, registered as an officer of, property, deeds, mortgages, vehicle licenses and registration, property taxes, violations and fines. All of those things are out there. Some of them are not very convenient to find, but they're all a matter of public record. And anybody who wants to dig can find these things out about us without getting a consent to a background check. That said, in a practical sense, it's very unlikely that a landlord would do all of these things. They can be expensive to do. They can be time consuming. These are the kinds of things that private investigators look up, and landlords are certainly known to hire private investigators, but not to do checks on applicants. They are more known to do these things when they suspect or are fishing for evidence that a tenant might be doing something that they could get evicted for. I've never heard of a landlord hiring a private investigator to look into applicants because I think it would just be extremely expensive. And because they know that if they make you sign a consent form to a background check, you'll do it. We've all done it. But those are the laws such as they are protecting us from background checks. So I promised that I would talk more about criminal history. Very recently, the New York City Fair Chance Housing Law was passed, and it became effective in January 2025. So this is very new. And it's pretty unique. I do not know if there are other cities that have passed a law like this, and I know that no states have. And it limits how landlords can consider criminal records. when someone is applying for housing. It is still legal for landlords to do a criminal background check or to require you to consent to one, but they can't do it until after they've considered an application and made a conditional offer. In other words, already considered everything else about your application and said to you, everything else looks good. Everything else I'm willing to rent to you. Uh, and I'm actually making you an offer conditional on certain things not appearing in your criminal background check. And the reason it's set up that way is because otherwise it's just it's difficult to impossible to ever find out why a landlord made a decision, right? If they're considering everything at once, they could decide that they don't want to rent to you based on a forbidden reason, but just say, oh, I got a better offer somewhere else. This way, they have to go on record saying they're ready to rent to you, and nothing else besides the criminal background check is a basis for them refusing. Then they can say, in order to finalize this, I need you to sign a consent to a criminal background check. Then when they have done the check, this is where there's kind of a very big hole in the law. They can then say, no, I'm rejecting your application. I won't rent to you. And it is just because of your criminal record. If they're pointing to one of these specific things in a criminal record, one is crime that requires registration as a sex offender. Two is a felony conviction where the actual end of the sentence was within the last 5 years. Misdemeanor convictions where that was within the last 3 years. And then, as we said, reasons unrelated to convictions, which they would have rejected you on before they ever did the background check. You're probably noting, those are pretty big exceptions and allows landlords to refuse to rent to people, for a pretty broad swath of criminal background. It is, still a difference from the way things used to be, and it does aim at, permanently excluding people from the legitimate housing market because they were convicted of a crime in 1983, right? They also, in doing this, cannot ask you about things that don't show up in a criminal background check. Criminal background check only shows convictions. And so, up until this law was passed, landlords could just ask you about other things, like, have you ever been arrested? Do you have a case going on right now, but there's no decision? Were you convicted of something when you were, under 18, a juvenile, and it's sealed now? Have you ever gotten an ACD, which is a kind of a very conditional dismissal of a criminal case? In other words, the landlord cannot ask you about anything that doesn't show up on a criminal background check. I should add, this doesn't apply to owner-occupied 1 or 2 family houses, and it doesn't apply to public or subsidized housing because those kinds of housing are already governed by very strict laws, federal and state laws, about how they have to treat criminal backgrounds. And the city doesn't have the power to overrule those things. So those are exceptions. And that's about all I've got to say about tenants' privacy. As always, these slides will be shared. You don't have to, write down all of these websites. They will be shared out by Cooper Square. But the New York City Commission on Human Rights has comprehensive information on housing discrimination, what your rights are, and what someone can do if they have been discriminated against. They have a page specifically dedicated to the fair chance in housing law because it's new. And here are some good, reliable pages about the federal Fair Credit Reporting Act.